another session of TechLawConverge. As you know, this is a channel um, podcasting for you, very relevant content, simplifying the law and technology. Today, I present to you another interesting session. Again, my name is Desmond Israel, as you already know. For those joining us for the first time, you're presented here. The legal disclaimer is that everything we deliver here is for educational content only. We do not intend to provide you legal advice. We could, however, do that in the right forum. So before the session starts today, which is supposed to talk about cybercrime and the law, we would do a little bit of tribute to one of my very fine cybersecurity persons to ever lived by my standards, Kevin Mitnick, Kevin David Mitnick, and he had held out to be the finest. Like I said, those of you who know before, yeah, that's the technical brain behind it. He was a security advisor to the Wall Street. He started off with that biggest hack written down in history with the FBI arrest. He wrote books like Art of Invisibility. He wrote Ghost in the Wires. Yeah, he's a legend. And if you ever use the statement, the weakest link to cybersecurity is the human being or the people, that is a dude that said it. Rest in peace to Kevin Mitnick. Um, Maybe when we meet where we're supposed to meet someday, I could tell you how much I admire you. Okay, jumping in straight to subject matter for today, we will be dealing with cybercrime and cybersecurity law. By way of signposting you, as usual, we would be like touching base and understanding cybercrime, also looking at cybersecurity and the legal frameworks that are there, and then understanding prosecution and cybercrime itself. Of course, we will also look at some best practices just to align with it. So yes, let's make the best use of our most solid 20 minutes ever on podcast. So cybercrime essentially is something that we need to look at, put it in proper context, because crime is a matter of law, okay? And for those who might not know, crime must be defined in law. It's actually one of the principles when it comes to the practice of criminal law. So cybercrime is just one of those components of criminal law, which means that anything you claim to be a cybercrime should have been defined in one law or the other. So on the right of your screen, you will see the funnel and a beaker. For my science guys, you might probably, align with the terminology more, but that's not the purpose of putting this up. This is just to explain to you that what you have in the funnel is an activity, right? And then, so the liquid in the funnel is an activity. And then you have the funnel itself, which you can consider to be the law and the regulations. And then you have cybercrime. So essentially, an activity becomes a cybercrime if a law says so. And that is why if I did a brute force attack on the system, or if I did password guessing on the system, the activity of brute force attack and the activity of password guessing itself might not be a crime unless that activity produces an outcome within which a law requires it to be a crime. And usually this would be an unlawful access or unauthorized access, unauthorized modification, unlawful modification, and the rest. So if you did a denial of service, if you engage in denial of service, for instance, you are and that denial of service causes people not to be able to access a regular running service, and denial of service is deemed to be that denial of service is deemed to be an unlawful, unauthorized interference of a regular service, then you would be charged for a cybercrime, whereas the activity would be based on the fact that you did cause denial of service attack, right? And that's why it's important for us to understand how cybercrime itself comes to being. So a little bit of description for you, a walk away description for you would be that a cybercrime is a criminal activity that either targets or uses a computer network or a network device. Then you have some sort of statistics from Statista which I would like to share with you. So this is reference to FBI's Internet Crime Report 2021. So that gives you a bit of everything that is happening around since 2021. So you have the BECs, which is the business email compromise, topping the list. So usually this is when you have emails being sent to you with all sort of goodies in there, like the Nigerian prince emails where you receive somebody saying is a prince somewhere. He can get you access to business, maybe gold, diamonds, and stuff. And then they get people to send all sorts of money to them. So they create some sort of business context within that email. And then they use that to bait people into parting away with their valuables, including cash. Then we have investment stage fraud attacks as well. They come in all sorts of manner. You've seen Bitcoin scams. We've seen some other scams that are built on the pyramid style of scamming, which comes through various means, various electronic communication means to get you to participate. And you have confidence or the romance fraud, reference to Hajia. She's in the US going through some sort of prosecution as we speak now. She's formally charged with romance fraud. So it's something we can easily reference to on this channel. Of course, she's on the record as formally being charged, but she's still guilty until proven innocent. And then you have personal data breach, which happens to most companies. If you check Information is Beautiful, that portal will give you most of the recent personal data breach that has happened across. I mean, it doesn't matter the company size. And then we have the real estate and the rental also being some sort of cybercrime, especially in the United States. And then tech support scams are based more in India, where they have like a growing cybercrime platform for these things. The perpetrators or the attackers represent themselves as though they work with tech giants, and then they get people to part away with their money. And then we follow up with non-payment and non-delivery, and then the credit card fraud. Back in Ghana, we know this started off as something we called the local parlance as Sakawa. And then we have the corporate data breaches also happening, where not personal data is involved, but then you have what corporate data like intellectual property theft and things like that. Lockheed Martin has an example of this, when they actually said that the People Republic of China is suspected to have been engaged in some of these um, um, corporate data breaches or corporate data theft, and then you have government impersonation. So that's really the coolest statistics I can give you for today, to give you a perspective of what we are getting ourselves into in terms of the subject matter. So let's go on and then look a bit more into the legal frameworks now that you pretty much appreciate the whole idea of the activity and then the law and the regulation that actually makes up a cybercrime. Right. So there we have the next session. Now, on the next session, you're dealing with the legal frameworks. Okay. Now, the legal frameworks usually will come in like maybe two flavors. The national frameworks and then the international frameworks. So you really have like national frameworks, like in Ghana, for instance, you have a Cybersecurity Act. We have other acts that also support the Cybersecurity Act. And then we have the Computer Fraud and Abuse Act from the United States as example. Another example I can give you, the CMA, which is the Computer Misuse Act from the UK. And then maybe the final example I can give you is from Ireland, which is the Criminal Justice and Offensive Relating to Information Systems Act of 2017. Then there are international frameworks like the ECOWAS Directive, the Budapest Convention, the Malabo Convention. Malabo Convention is for the African Union, and then the Budapest Convention is the European Union, but was open up for other international states to sign up to. And so these various frameworks, legal frameworks, define certain activities in there, okay? And those activities would amount to cybercrime if you engage in those activities. The essence of most of the international frameworks is kind of like harmonize or get states to be able to do like have a standardized sort of crime, and then also help in international collaboration when it comes to the fight of cybercrime, through mutual legal assistance, resources, investigation, forensics, repatriation, or expedition, and the rest. And then you have on the other side of your screen examples of some of the activities that, whether authorized or unlawful, that can actually lead to a cybercrime, if it goes through the final test of a regulation. So you have like password guessing, which I tried to use as an example earlier. You can exploit vulnerabilities. You can exploit vulnerabilities for fun, but if you exploit vulnerabilities and then it violates a particular set of laws, you might be dealing with cybercrime. You can engage in social engineering. You can engage in tailgating, piggybacking. So tailgating is essentially when you try to follow somebody closely and then enter into an environment when they have authorized access and they enter, then you follow them and enter with them. And then you have fraudulent use of access cards. Well, this has fraud in it already, so by itself as an activity is what is unlawful and potentially a cybercrime, depending on which legal framework test you're putting it through. And then you have collusion. And then door propping. Collusion essentially is when people come together. So I work with an institution, I have credentials, and then I give my credentials to a bad guy or a third party who uses it to compromise the environment. These are things that you can actually term as a cybercrime. There's a case in the United States, for instance, where a party who had left a job environment and wanted to compete with that job environment gave his credentials to third parties who were his partners to gain access to information within that environment to be used. The activity was deemed to be a criminal activity, especially when he gave his credentials out, and at the time he was accessing, he was no more an employee of the place, and so that was an unlawful access to the intellectual property which they were charged with. And so that's how you can look at collusion when it comes to dealing with it. And then pass back credential sharing is similar to the collusion, but um, it just deals with the credentials and not necessarily the entire scheme of the crime. So before an activity can become a crime under the cyber law, usually the final test is whether it's unauthorized, okay, or unlawful access and breaks the law. And you also have other activities which they are not ancillary. There are other activities that can actually also be categorized as a final test for cybercrime, like when it's unlawful modification, okay, when it's unlawful interference. Unlawful interference could be very simple, um, like a DOS, which I made an example for. We could also have um, uh, unlawful interception, right? So unlawful interception is when data between A and B is being communicated, maybe at the airport. I'm trying to make payments on an online banking platform, and I use the airport Wi-Fi, and I fail to maybe apply a VPN or apply the security, and then there is an attacker on the same Wi-Fi in the airport who then like extracts, or through what we call the man in the middle attack, is able to see the credentials or the information that I'm passing on to my to the payment server or to the banking server or wherever it is, and then he's able to take that information and then use it. So that unlawful interception itself can also, sorry, that interception itself would be unlawful because it doesn't have permission to do that, and most cyber crimes or legal frameworks would run that final test to make it a crime. But now when it happens, when that activity breaks a law, usually you can say that there's a criminal liability. But when that activity breaks a disciplinary action within an environment, or maybe breaks a contractual requirement, then you are, sorry, ethical or contractual requirement, my apologies, then you are dealing with a disciplinary action, or a civil liability. Now you need to understand this because sometimes people do get like valid engagements, and then out of it, the issue of cybercrime um, comes up as a way of a byproduct, like a pen tester who is engaged in doing a legitimate job, but then goes out of scope on the job he's doing. The question is whether he had permission to go out of scope. And if he did not have permission to go out of scope, is it a criminal activity or is it a civil activity? So some of these gray areas when it comes to determining what actually the crime is could also be a potential issue. And I can give you an example. For instance, there was a police officer, actually an FBI officer, who got went rogue, and then the FBI set up a counterintelligence on him and got one of their agent provocateur, who is like somebody who's trying to get him to act, get him to act, to get a certain information about a criminal and give it to a third party. So this was staged, and then he did that. But when the matter went before the court, they were trying to argue unauthorized access, you see, which is why this podcast is important. Unauthorized access must be unauthorized access as required and defined by law. This gentleman or this agent had access. It's just that when he took out the information, he used it for something that he's not supposed to use it for. So the court's position was that he cannot be a crime under the definition of the law. But that doesn't mean that he's not subject to disciplinary action. So these things happen within companies where we've given people access to database and stuff like that. And then a whole lot of things happen, and you might end up in court, thinking that you have a very good case, and it's because either prosecution or that either the prosecution didn't do a pretty good job in identifying the crime itself and the components of it, or the defense did a good job by seeing that the activity you deem to be a cybercrime indeed is not really a cybercrime under the meaning of the law. So it's quite a brief session for us on this podcast, but quite an important one as well. So let's look at another component of it now that I've explained these area of things. Just before I switched over to ethical standards are usually built from like professional bodies and international bodies. So you can have like both the domestic and global. So like maybe a domestic body that deals with maybe IT professionals, a domestic body that deals with maybe IT security practitioners and have certain ethical requirements of what they're supposed to do. And then global bodies also can come in handy, like the ISACA, the ISC squared, the EC Council, CREST, ISO, and the rest. Jumping on to the next. Now you know the crime. So what happens when the crime is committed? So we've moved away from the activity stage, the commission of the crime itself. So with the commission of the crime, once the crime is committed, what happens is there has to be a determined nature of the cybercrime. This is why you need to really understand the legal framework. So even the prosecution need to appreciate the legal framework, because the prosecution must put the activity within the context of the legal framework and determine what has actually happened is really a crime. And then they move into conducting initial investigation, where they try to gather all the information around it. They could do open source intelligence, they could do overt activities trying to gather information concerning the crime, the commission of the crime. And then they will identify maybe if there's a digital evidence. And this is where it gets tricky. Between the identification of digital evidence, the performance of the digital forensics on devices that are available, and then the securing of the digital devices and the evidence, there is what we call the chain of custody. So these three activities you require to imbibe the chain of custody, because if the evidence is contaminated, which is possible, lawyers get the opportunity under most rules of evidence in court, to challenge these evidence that you are digital evidence you are presenting. And there's a very high likelihood that when you present digital evidence of that nature which are contaminated, you're not going to get a conviction when you present the evidence before a judicial system. So that's the process they go through in investigating and prosecuting cybercrime. Clearly, the key takeaway here is, the determination of the crime, the conduction of the initial evidence, identifying and preserving the evidence, and then presenting it before a judicial system. So in the judicial system, you have the prosecution, which is going to deal with a criminal case and try to get a conviction, and you have the judge who is going to usually in some jurisdiction they have like special courts for that. In other jurisdictions, just a general court with judges trained to appreciate the law and appreciate some of the technical issues. They could bring expert witness into the environment to help them understand things that have happened before they pronounce judgment on this. And then the judgment usually is based on what the law says. So the law will define the crime, the law will state the penalty for the crime, and then on that basis, if there's a conviction, yes, then the judge would actually present the conviction and offer sentencing to that effect. So remember that there's always an investigation and prosecution when cybercrime is involved, and that can cover cybercrime can cover both individuals, government, corporates, and even and entire society. Crime can be committed against any of these persons. In the final summary, best practices that you can be looking at is so best practices, we can have like an umbrella best practice that covers everything here, as in cybercrime against individuals, against companies, against society, against government. Essentially what you need to have is to have a very good cyber hygiene in your environment. So cyber hygiene would include the best practices that both individuals and organizations will use. Strong passwords, keeping your email secured, not sharing your credentials, keeping your phones, your laptops, your devices secured, moving sensitive data away from people that are not authorized. Principle of least privilege, who can access what. Even in family settings, you can have multiple accounts for who accesses what. Not using insecure platforms, insecure websites. In corporate environments, you are adopting standards like ISO 27001, NIST, cybersecurity framework, CIS controls, PCI DSS, and the list goes on and on and on and on. Most important is also to keep to compliance, because sometimes when you get to prosecution and these things are before the court, you are also judged and tested against some of the best practices that are supposed to be in your environment. So remember your data protection laws, remember incident reporting, remember data breach notification requirements, especially for a much advanced environment. And again, for the government, there's always an impact to cybercrime to its social, economic, political, and technology well-being. So this is it. We just wrapping up right from here. So we will be coming back to you with the next session on TechLawConverge. Connect with me on the handles that you see on your screen. My email, the YouTube where these videos are posted, my Twitter, and also on LinkedIn. On the next time when I see you putting up another one, thank you for connecting, and I'm surely gonna see you guys again.